Hello friends, this is Aniruddha and today we are going to discuss one of the famous case law of Income Tax Act. The name of the case law is Shanti, Bhushan versus CIT. So before dive into the case law, I just want to clear one thing that I am not discussing the case law from any reference book available in the market for chartered accountancy course or any other professional courses. I am discussing the case law directly from the decision given by the court, and I am downloading such case law directly from the authenticate website of the court and discussing with you. So let us discuss the case law. The fact of the case is like this. There is one practicing advocate of the court who incurred some expenses on his heart surgery and claimed such expenses as a repairs to plant under section 31 of the Income Tax Act. Basically, he is considering his heart as an asset of his profession, and he incurred expenses on his heart and claiming such as a repairs to his heart. So he considers such expenses as a professional expenses and file his return of income. While assessing the income of such assessee, assessing officer found such expenses, and assessing officer is of the view that such expenses cannot be allowed as a professional expenditure. It is purely a personal nature expenditure and cannot be allowed. So he refer case to commissioner. Commissioner also is of the view that such expenses is purely a personal nature expenses and cannot be allowed as a business expenditure or professional expenditure. So department disallowed such expenditure. So issue here under consideration is that whether heart is considered as a plant of profession, and second, whether repairs made to plant can be allowed as a professional expenses or repairs to plant under section 31 of the Income Tax Act. This is what the fact of the case and issue under consideration. Now, party agreed by the decision of the assessing officer filed a case to CIT appeal. Where now case is in the court of the CIT appeal, where assessee made a series of arguments. So we will discuss the argument made by the assessee. First argument made by the assessee is that he said, see, I am involved into a professional business, and for that purpose it is necessary that I must have heart, without which how I am going to carry out my profession. So heart is a necessary, and without which I am not able to carry out my profession. So heart must be considered as an asset of my profession, and any repairs made to such heart must be allowed as a repairs to plant under section 31 of the Income Tax Act. I am also demonstrating you that my professional receipt gone up substantially after such heart surgery. You can check from my books of account and my receipts book. So considering this issue, that expenses must be allowed as a professional expenditure. In second argument, assessee refer case of Mahbub Production versus CIT. Here there is one director of the company who is a driving force of the company, gone abroad for business purposes, and where he suffered from heart attack. So medical facility provided to such a director out there in abroad were allowed to company. So that was the decision given in Mahbub Production versus CIT. So assessee says fact of that case is similar to fact of our case, and considering the reference of this case, expenses must be allowed as a professional expenditure. Third, he said, if you read the definition of the repairs to plant, it is an inclusive definition. So something which is not included in the definition may also get included in definition, considering the circumstances and the fact of the case. So circumstances and the fact of this case warrant that expenses to repairs of the heart must be included in the definition. And finally, he said that, see, if there is an alternative argument arise and it has been decided that the expenses cannot be allowed as a repairs to plant, then it is surely allowed under section 37 subsection 1 of the Income Tax Act, as it is incurred for wholly and exclusively for the purpose of profession. So that was the various arguments made by the assessee. Now we will discuss the view of assessing officer.